Good morning, ladies and gentlemen. Today is April the 4th. It is 10:03 a.m. We're here today in docket number 2021-324 WS. Before we get started, please join me in a brief moment of silence. Thank you, ladies and gentlemen. All commissioners here in this case are present in the hearing room. Attorney Butler, if you would please read the docket, sir.
Good morning, Mr. Chairman, other members of the commission. This is docket number 2021-324 WS, the case of Kiawah Island Utility Incorporated. The company's filed an application which, if granted, would result in an increase in rates and charges for the company's customers, as well as modifications to certain terms and conditions for the provision of water and sewer service. On March 28, 2022, a settlement agreement was filed in the case. Signatories were the Office of Regulatory Staff, Kiawah Island Utility, and the town of Kiawah Island. The only remaining party, the South Carolina Department of Consumer Affairs, also filed a letter on March 28, 2022, which stated that although the department was not a signatory to the settlement agreement, the department does not oppose it. A public hearing in this matter was held on March 21, 2022. Hearing on the merits of the case before the commission was set for April 4, 2022 at 10 a.m. in the offices of the commission. Mr. Chairman, other members of the commission, the docket is in order.
All right, thank you, Attorney Butler. Before we recognize the parties, I think despite the fact we had a moment of silence, it's a good time to pause and give thanks, because this is the first time that the commission has had a hearing with no parties virtual in over 2 years. So this is quite an accomplishment, I think, and I appreciate all our staff for making our virtual appearances possible, but it's good to be in person. So just want to thank everyone for deciding to show up in person. We appreciate that. It makes a difference. All right, let's go through our parties to introduce ourselves to each other. We're going to start with the interveners, yes, the interveners, the town of Kiawah Island.
Mr. Chairman and Commissioners, my name is Jack Pringle, here on behalf of the town of Kiawah Island.
All right, thank you, Mr. Pringle. And so I understand we're all spread out here, and the way we have the courtroom set up, if the lawyers want to go to the podium, they can, but you don't have to. It's your preference. We just have that available for you if you feel more comfortable standing up, but if you choose not to do that, you're fine as well. It's your choice.
Yeah. And Mr. Chairman, I understand now that at the time of introductions, I was also going to set the table a little bit for the hearing today, if that's okay with the chairman.
It's fine with me.
Okay. And then the other parties can also introduce themselves.
Absolutely.
All right. Good morning, Mr. Chairman and Commissioners. I'm Jack Pringle of the firm of Adams & Reese, and I'm representing the town of Kiawah Island in this proceeding. The town, the ORS, and KIU have agreed to settle this case pursuant to the terms of a settlement agreement that was filed with the Commission last week. And as was previously mentioned, while the Department of Consumer Affairs is not a signatory to the settlement agreement, the DCA has indicated that it does not object to the settlement and is, of course, appearing here today. The settlement agreement addresses all of the contested issues, and they form the basis of that settlement agreement. Initially, I'd like to thank Chief Hearing Officer Butler and all of the members of the Commission staff who worked so diligently with all of us to work out the procedural kinks and to take all the actions that got this settlement in front of the Commission. It is certainly no small project to make that happen, and Mr. Butler's availability for status conferences and calls, I won't say at all hours, but at all hours of the day and all times of the week. He was always available on relatively short notice in order to help us work through some of these procedural things. In the case in chief, KIU filed the testimony of seven different witnesses. Town of Kiawah, my client, filed the testimony of one witness. The Department of Consumer Affairs filed the testimony of one witness, and ORS filed the testimony of 6 witnesses. So there's a lot of direct and rebuttal and surrebuttal testimony that took place. My client, Town of Kiawah, met last week to review and discuss the terms of the settlement agreement, and at the conclusion of the meeting, the Town Council voted to approve the settlement agreement and to recommend approval by this commission. As was mentioned, KIU's rate application sought somewhere in the neighborhood, and I get lost in the numbers, but about $1,355,000 in additional annual revenues. The settlement agreement reduces the proposed increase to approximately $550,000, which is something in the neighborhood of a 60% reduction in what was sought in the rate application. This substantial reduction in rates provides real savings to the town's customers, or those residents of the town of Kiawah. And also the settlement represents a real good faith compromises by all the parties in order to achieve their various interests, whether it's rate certainty or the kind of expenses and resource commitments that are associated with a fully litigated contested case before this commission. And I'll just briefly touch on some of the major provisions in the settlement agreement. The settlement witnesses will certainly do this in some more detail. First, is in terms of the rate of return methodology. Originally, KIU filed its rate application proposing to use operating margin. As part of the settlement, KIU is agreeing to set rates applying the rate of return on rate-based methodology. And in addition, KIU agreed to file its next rate case using the rate of return methodology. And this is obviously a significant and beneficial outcome for my client. And moving to another issue, it might not surprise this commission to learn that the parties had some pretty different opinions about ROE, return on equity. The Department of Consumer Affairs and ORS and KIU each had an expert offering testimony about an appropriate return on equity. And they resulted in ranges that went from 5.75% to a high of 9.60% ROE. And after a lot of settlement discussion, the parties agreed to adopt an ROE of 8.69% for the settlement. It also involved a capital structure that had 53.19% equity and 46.81% debt, and adopted KIU's actual cost of debt of 4.57%. And all these inputs, or they may actually be outputs, but these figures combine to produce an overall cost of capital of 6.76%. Second, KIU had sought to recover about $2.4 million in rates for certain costs associated with the construction of a secondary water pipeline. Won't go into the particulars here, but after a lot of discussion, and the issue involved a lot of insurance coverage concerns and litigation and the results and what that meant. But after that process, the parties agreed that KIU's recovery of pipeline construction costs would be $1.8 million that's placed in a regulatory asset account and amortized over a 30-year period. And that doesn't include any carrying costs. The settlement witnesses will unpack that a little bit, but That was the settlement. And it also, the settlement will mean that going forward, KIU won't seek any additional costs associated with that secondary water line or that secondary pipeline. The settlement requires KIU to conduct a couple of studies, a lead lag study and a shared services study that will be used in future rate cases. And that's, if you look in the settlement agreement at paragraph 20, that's where those two studies are discussed. And then finally, the settlement limits the recovery of certain executive compensation and corporate development team overhead costs that KIU had sought, and that's a compromise that the parties reached. In conclusion, the settlement agreement definitely balances the interests of my client and the company, and it substantially reduces that revenue increase sought by KIU. The town is pleased to be a signatory to this agreement, and I'd say again, it was a result after a number of fairly intensive and involved settlement discussions between the parties. And I appreciate, just personally, professionally, appreciate how hard the parties fought, but how they did so in a very professional and respectful way, and ultimately got to that middle ground that is the result that we're bringing before you today. And I don't think it would have happened had everybody who's in this room who's been involved been sitting at the table or discussing this in good faith and being willing to have frank discussions about their positions and their interests in terms of getting towards something that we could be, I don't know whether the term is proud to bring before the commission, but I think it is, in terms of, because it doesn't involve everything everybody wanted, but that's the nature of compromise. Anyway, thank you for the opportunity to appear this morning, and others will explain what is happening and what's going on in some more detail, and can certainly answer questions as we go along. Thank you.
Thank you, Attorney Pringle. South Carolina Department of Consumer Affairs.
Good morning, Mr. Chairman, members of the commission. I'm Roger Hall with the Department of Consumer Affairs. I'm the Deputy Consumer Advocate at the department, and also with me is Connor Parker, our Assistant Consumer Advocate. I'll just be very brief. As Mr. Pringle has already stated, the department intervened in this matter to represent the consumer interest, but in this case, a little bit uniquely, the town of Kiawah also represents the consumer interest. We participated in the settlement discussions. We ultimately did not sign it, but we do not object, as been indicated, and we very much appreciate the commission scheduling this day as a settlement conference, or settlement hearing rather. I have agreed to stipulate our witnesses into the record as provided in the settlement agreement, and happy to answer any questions that you may have, but I just want to say that a few words, and again, thank you for scheduling this as a settlement hearing. Thank you.
Thank you, sir. All right, let's hear from the applicant.
Thank you, Mr. Chairman, members of the commission. I'm Vincent Shaheen. I represent Kiawah Island Utility. I'm thankful to be here with you today on this bright and beautiful Monday morning. I also want to introduce some of the rest of our team, our attorneys as well, Charlie Torini and Scott Elliott, who you've met on many occasions. Also members of our executive team, including Craig Sorensen and Becky Dennis, who you'll hear from today as well. And I also want to thank the joint effort that has arisen so that we could bring you this agreement today, especially David's hard work, being on the phone when needed, and volunteering his time as needed. Also, our friends at ORS, who've worked really hard on this as well. Thank all of you. Alex Knowles, Donna Rainey, Dawn Hipp, and Steve Ham, and all the rest, and the consumer advocate, who came at this with a strong cooperative as well as advocacy approach, which we appreciated today as well. Very briefly, I came to work with Southwest and Kiawah Island Utility over the last 6 months. And primarily my role is to help them increase and improve investment in South Carolina. I was brought on board to further ground them in the culture and the people of the state. And mostly that is helping them evaluate opportunities for growth, investment, and expertise that they can bring to the state of South Carolina. But it also involves improving and bringing a cooperative effort to their regulatory interactions. And that includes with ORS, with the Commission, with DHEC, and other regulatory entities in South Carolina. And that is key for their opportunity to grow and benefit the state in a way that the state wants and desires and will benefit from, as well as the company's efforts to grow in South Carolina. You will hear more in the evidence about this settlement, but let me just pause to say that this literally took weeks and weeks and hours of intense negotiation, back and forth, strong advocacy on the part of all the parties who are here today, and arrived at what a settlement should be, and that is fair. Not everything that Kiawah Island Utilities wanted, not everything that the town wanted, not everything ORS wanted, not everything that the consumer advocate wanted, but a result that is fair, most importantly, to the ratepayers, to the customers in this case, and also the utility that is the subject of this case as well. I want to touch on just a couple of the highlights as I encourage you to evaluate this settlement proposal that is put before you today and adopted as your own. For Kiawah Island Utilities, you heard from Jack some of what our compromise was. But we did agree to a return on equity of 8.69, which is significantly below the 9.35 recommended by our expert witness, but is higher than some of the other expert witnesses that were presented to you in the case, and is a fair rate given what you will hear today. You also hear that we've agreed not to file our next rate case any sooner than 18 months from the Commission's order. So that was an agreement that we were happy to reach as part of the overall agreement. We will earn, and Jack touched on this, but I think it's important, no return on the $2.5 million it paid for the secondary pipeline. We'll recoup some of the cost, but it's not built into our rate base. And that was very important to ORS, and we found a way to make it work. I'll close by saying the ability to resolve these cases through negotiation and agreement is incredibly important to the success of the utility and our ability to provide the services at a very high quality level that's needed by our customers, and we're proud and thankful to be able to do that and appreciate your consideration today. Thank you.
Office of Regulatory Staff.
Good morning, Mr. Chairman, Madam Vice Chair, members of the Commission. I would fully echo everything that you've heard from the parties today. We're very appreciative of the effort of Mr. Butler and Commission staff to help facilitate and make possible this settlement agreement and settlement hearing. We very much appreciate the hard work of KIU, the town, the department, to help make the settlement possible. We're very pleased to have this settlement agreement to present to the Commission and to recommend for your approval. And I suppose I should say with me today, Ms. Donna Rainey, Mr. Steve Ham, and Ms. Hipp, who you will be hearing from shortly. So thank you again for your time this morning, and we look forward to presenting today.
All right. Thank you very much, everyone. The spirit of compromise is all throughout the hearing room, and we appreciate the spirit of compromise and the level of professionalism that has been demonstrated not only this morning but throughout the case. Commissioners, before we call the first panel, are there any questions for the lawyers? All right, hearing none. So I'm going to rely on you, Attorney Pringle. Who's going to testify first?
And I may transfer my reliance to somebody else. I believe the town is gonna, that the KIU ORS is going first. Right.
Okay.
Yeah.
Let's go through that just so we know, get an order. We're going to hear from the Office of Regulatory Staff and Ms. Hipp.
Would just be, yeah, Ms. Hipp will be the ORS settlement witness.
Right. And what about the applicant? Who will we hear from?
Mr. Chairman, we'll present a panel of Craig Sorensen and Also, the parties in the settlement agreement agreed to stipulate the direct and rebuttal testimonies of several witnesses. I don't know at what point you would like that done.
We
It
can,
might be that they're doing it. Okay.
Mr. Trini, could you get to a microphone because
Yes.
we are live streaming and,
Is that working now?
yes, and Mr.
Okay.
Pringle, you may need to pick that up as well, just so folks can hear you, please. Thank you.
So do I need to, should I restate? I don't know at what point you, Mr. Chairman, you would like us to stipulate, enter the stipulated testimony into the record. We're willing to do it as we take our
it's your
turns.
preference.
Or
Whatever makes you feel the most comfortable. I'm good either way.
It
You
might
can do it
make
when you
sense.
present your panel. You can do it now.
since the town is first in order and they're going to stipulate, I think it might make sense for everybody to go ahead and
Go through it.
stipulate.
Got it.
So then you just have the live witnesses to deal with.
Yes, sir. That's fine.
That certainly makes
Let's get
sense.
started.
All right, with that in mind, the town filed the direct testimony of John D. Labriola. This morning, the town also filed a verification along with to go with Mr. Labriola's direct testimony. So I guess at this time, I would ask that the direct testimony of John D. Labriola, consisting of six pages, and including one exhibit and a verification, be marked for identification and entered into evidence. And I could back that out to the testimony and then the exhibit if that made sense. So let me try that again. Take two. I'd like to ask that Mr. Labriola's direct testimony, consisting of 6 pages, be marked for identification and entered into evidence at the hearing, as part of the hearing.
All right. Mr. Labriola's direct testimony will be marked and entered into the record as hearing exhibit 2.
Thank you, Mr. Chairman, and
I'm sorry, read into the record.
read into the
Thank you.
record. And Mr. Labriola also included one exhibit to his direct testimony, and I'd ask that that exhibit be marked for identification and entered into evidence as appropriate, either as part of the record or as a hearing exhibit.
All right. Mr. Labriola's exhibit will be marked as a hearing exhibit 3 and entered into the record. So our sign-in sheet from the public testimony is number 1, and okay. Oh, I got you. And so Mr. Labriola's exhibit is number 2.
Thank you, Mr. Chairman. And then, I guess finally, and I don't know how this fits in, that Mr. Labriola's verification also be part of the record or made an exhibit as is appropriate. He's attached it. It's been attached to the testimony. Okay.
All right.
I think that manages the town's testimony.
All right. Thank you very much, sir. South Carolina Department of Consumer Affairs.
Thank you, Mr. Chairman. The department filed one witness in this matter, Aaron Rothschild. With the consent of the parties, we would stipulate him as an expert on the fair rate of return for a regulated entity, including its cost of debt, return on equity, and capital structure.
Okay.
Mr. Rothschild's direct testimony consisted of 92 pages, also accompanied by 37 pages of appendices and exhibits. I would move to have his direct testimony entered into the record as if given orally from the stand.
All right. Mr. Rothschild's direct testimony will be read into the record as if given orally from the stand.
And again, his direct testimony was accompanied by 37 pages of appendices and exhibits. There were appendices A through C. Appendix C consisted of exhibits ALR1 through ALR6. We'd ask to be marked as the next hearing exhibit.
So appendices A through C that include ALR 1 through 6 will be marked as a composite exhibit and entered into the record as hearing exhibit number 3.
Thank you. Mr. Rothschild also prepared 23 pages of surrebuttal testimony. There were no exhibits with that testimony. We would ask them to be read into the record as if given orally from the stand.
And Mr. Rothschild's surrebuttal testimony will be entered into the record, read into the record as if given orally from the stand.
Thank you.
And his expert qualifications have been stipulated to and accepted by the commission.
Thank you.
Thank you, Mr. Chairman. For ORS, I'll first stipulate to the qualifications of ORS witnesses Herpel, Rabin, Hunnell, Watkins, and Garrett. For Herpel and Rabin, we would ask that they be stipulated as an expert in accounting and accounting principles. For witness Hunnell, we ask that he be stipulated as an expert in utility rate making and regulatory analysis. For witness Hip, ORS asks that she be stipulated as an expert in public utility regulatory policy. For witness Watkins, we ask that he be stipulated as an expert on rate design, class cost of service study, and class cost of service studies for regulated utilities. And for witness Garrett, we ask that he be stipulated as an expert on the fair rate of return for a regulated utility, including its cost of debt, return on equity, and capital structure.
Okay, so witnesses Herpel, Hunnell, Watkins, Garrett, and Hip, expert qualifications have been stipulated to, and all of those are accepted by the commission, and they're qualified as experts in those areas.
Thank you very much. ORS witness Garrett pre-filed 66 pages of direct testimony on February 24th, and he pre-filed 13 pages of surrebuttal on March 28th. His verifying affidavit was submitted on March 31st. We would ask that witness Garrett's pre-filed direct testimony and surrebuttal testimony be read into the record as if given from the stand.
I think co-counsel has something for you.
Oh, I see. Okay. Yeah, I'm sorry, I wasn't close enough to the mic. Would you like me to repeat that, Mr. Chairman?
I hear you.
Okay.
But those that are watching live may not. Thank you for that. Witness Garrett's direct and surrebuttal testimony will be read into the record as if given orally from the stand.
Thank you, sir. And witness Garrett, with his direct testimony, also pre-filed direct exhibits consisting of appendices A and B and exhibits DJG 1 through 17. And we would ask that those be marked as a composite hearing exhibit along with his verifying affidavit and entered into the record as the next hearing exhibit.
All right, understood. Witness Garrett's appendices A through B along with exhibits DJG 1 through 17 will be marked as a composite exhibit and entered into the record as hearing exhibit number 4.
Witness Herpel pre-filed 18 pages of direct testimony on February 24th and pre-filed 5 pages of surrebuttal testimony on March 28th. We would ask that those be read into the record orally as if given from the stand.
Okay, and you said witness Herpel, correct?
Yes, sir.
Right.
David M. Herpel.
Witness Herpel's pre-filed direct and pre-filed surrebuttal testimony will be read into the record as if given orally from the stand.
And witness Herpel, with his direct testimony, pre-filed direct exhibits consisting of exhibits DMH 1 through DMH 9. And we would ask that those exhibits, along with witness Herpel's verifying affidavit, be marked as a composite hearing exhibit and entered into the record as the next exhibit.
All right. Witness Herpel's exhibits marked DMH 1 through 9, along with his verification, will be marked as a composite exhibit and entered into the record as hearing exhibit number 5.
Thank you, sir. Witness Daniel P. Hunnell pre-filed on February 24th, 18 pages of direct testimony, and pre-filed on March 28th, 4 pages of surrebuttal testimony. And we would ask that witness Hunnell's pre-filed direct and surrebuttal testimony be read into the record as if given orally from the stand.
Witness Hunnell's pre-filed direct and surrebuttal testimony will be read into the record as given orally from the stand.
Thank you. Witness Hunnell, with his direct testimony, pre-filed 2 exhibits, DPH 1 through DPH 2, and we would ask that those exhibits, along with witness Hunnell's verifying affidavit filed March 31st, be marked and entered into the record as the next composite hearing exhibit.
Witness Hunnell's direct exhibits marked DPH 1 through 2, along with his verifying affidavit, will be marked as a composite exhibit and entered into the record as hearing exhibit number 6.
Thank you, sir. ORS witness Aaron Rabin pre-filed 8 pages of direct testimony on February 24th and pre-filed 2 pages of surrebuttal testimony on March 28th. We would ask that those, the pre-filed direct and surrebuttal testimony of ORS witness Rabin be read into the record as if given orally from the stand.
The pre-filed direct and surrebuttal testimony of witness Aaron Rabin will be read into the record as if given orally from the stand.
And we would ask that the verifying affidavit of Aaron Rabin filed on March 31st be entered into the record as the next hearing exhibit.
Mr. Rabin's verifying affidavit will be marked and entered into the record as hearing exhibit number 7.
ORS witness Glenn Watkins pre-filed 36 pages of direct testimony on February 24th and 14 pages of surrebuttal testimony on March 28th. We would ask that the direct and surrebuttal testimony of ORS witness Watkins be read into the record as if given orally from the stand.
The pre-filed direct and surrebuttal testimony of witness Watkins will be read into the record as if given orally from the stand.
Witness Watkins pre-filed with his direct testimony exhibits GAW through GAW1 through GAW12, and he pre-filed with his surrebuttal testimony, surrebuttal exhibit GAW1. We would ask that witness Watkins pre-filed exhibits along with witness Watkins' verifying affidavit filed on March 31st be entered into the record as the next composite hearing exhibit.
Witness Watkins' direct exhibits marked GAW 1 through 12, along with witness Watkins's surrebuttal exhibit marked GAW 1, and his verifying affidavit will be marked as a composite exhibit and entered into the record as hearing exhibit number 8.
Thank you, Mr. Chairman, and we'll do witness Hip when she takes the stand, if that pleases the chair.
That's fine with me. Thank you, sir. Kiawah Island Utility Incorporated.
Thank you, Mr. Chairman. Okay, thank you, David. Kiawah Island Utilities would first of all introduce the verified testimony of Donald H. Burkett, CPA, who filed direct and rebuttal testimony with no exhibits as if given orally from the stand.
Mr. Burkett's direct and pre-filed direct and rebuttal testimony will be read into the record as if given orally from the stand.
And at this point, I would move that Mr. Burkett be accepted as an expert witness in accounting and accounting principles as agreed to by the parties.
Mr. Burkett is qualified as an expert in accounting and accounting principles.
Kiawah Island next moves into evidence the verified testimony of Mujib Hafiz, who filed revised direct testimony into evidence as if given orally from the stand.
The pre-filed revised direct testimony and rebuttal testimony of Mr. Mujib Hafiz will be entered into the record as if given orally from the stand.
Mr. Hafiz's testimony also was accompanied by exhibits MSH 1 through 4, which we'd move into evidence at this time.
Mr. Hafiz's direct exhibits marked MSH 1 through 4 will be entered as a composite exhibit, and that will be hearing exhibit number 9.
We next move into evidence the verified rebuttal testimony of Mujib Hafiz.
I'm sorry, say that again, Attorney.
We next move into evidence the verified rebuttal testimony of Mujib Hafiz as if given orally from the stand.
All right. I think I might have jumped the gun on you there.
That'll be fine too.
I want to make sure my court reporter. I did that originally, did I not? Okay. I'm
That's-
sorry about that. I jumped the gun.
No, sorry, I just, I did these separately just because they had exhibits following the direct.
Yes, sir.
But either way is fine with me. We next turn to the verified testimony of Charles Loy, CPA, who filed verified direct testimony and verified rebuttal testimony in this docket, which I would move into evidence as if given orally from the stand.
All right. Yes, sir. Mr. Loy's pre-filed direct and pre-filed rebuttal testimony will be read into the record as if given orally from the stand.
And I would move into evidence the exhibits to Mr. Loy's direct testimony, which consist of Appendix 1 and Exhibits 1 through 4.
Mr. Lloyd's direct Appendix 1 and Exhibits 1 through 4 will be marked as a composite exhibit and entered into the record as hearing exhibit number 10.
And I would move the commission accept Mr. Loy as an expert witness in rate design, class cost of service study for regulated utilities.
Mr. Loy is qualified as an expert in rate design and class cost of service studies for regulated utilities.
We next have the verified rebuttal testimony of Benjamin E. Nicholson V, who filed only rebuttal testimony in this case, and I would move to have it admitted into evidence as if given orally from the stand.
Mr. Nicholas's rebuttal testimony will be read into the record as if given orally from the stand.
And I move to admit Exhibits 1 and 2 to Mr. Nicholson's rebuttal testimony into evidence.
Mr. Nicholson's exhibits 1 through 2 will be marked as a composite exhibit and entered into the record as hearing exhibit number 11.
Thank you. And I move to qualify Mr. Nicholson as an expert in complex insurance coverage and commercial litigation.
Mr. Nicholson is qualified as an expert in, could you say that for me again, sir?
In complex insurance coverage disputes and commercial litigation.
In complex insurance coverage disputes and commercial litigation. Did I get that right?
Yes, sir.
He's qualified as an expert in those areas.
Thank you. And last but not least, we have the verified rebuttal testimony of Douglas H. Carlisle, Jr., Ph.D., which I would move into evidence as if given orally from the stand.
Mr. Carlisle's rebuttal testimony will be read into the record as if given orally from the stand.
And Mr. Carlisle's exhibits DHC A, B, and 1 through 17, I also move into evidence.
Mr. Carlisle's exhibits DHC A, B, and 1 through 17. Okay, am I getting that right, Mr. Torini?
You are, yes, sir.
So Exhibit A, Exhibit B, and Exhibits 1 through 17 will be marked as a composite exhibit and entered into the record as hearing exhibit number 12.
And finally, I would move to qualify Dr. Carlisle as an expert witness on the fair rate of return for a regulated utility, including its cost of debt, return on equity, and capital structure.
All right, and Dr. Carlisle is qualified as an expert on fair rate of return, cost of debt, return on equity, and capital structure.
Yes, sir.
All right. He's qualified in those areas.
Thank you. And we'll offer our remaining witnesses as a panel.
All right. So let me ask this question. Is anyone going to offer the settlement agreement?
The settlement agreement is an exhibit to Mr. Sorensen's testimony, which
Roger that.
he will adopt shortly.
All right. Sounds good. Thank you very much. All right. Everyone has their evidence in the record. Okay. So we're going to start with Ms. Hipp.
do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Ms. Hipp.
Good morning.
Could you please state your name and occupation?
Certainly. My name is Dawn Hipp. I have the distinct honor of being the Chief Operating Officer with the Office of Regulatory Staff.
And are you the same Dawn M. Hipp who caused to be pre-filed 20 pages of direct testimony and exhibits HIP 1 through HIP 4 on February 24th, 2022?
Yes, I did.
And there was a public and a confidential version of your direct testimony and exhibits filed on February 24th, 2022. Is that correct?
That's correct.
A revised version of your direct testimony and exhibits was filed on March 30th, 2022. Is that correct?
That is correct.
And the only changes to the revised version were to remove certain redactions present in the public version of your direct testimony and exhibits filed on February 24th, 2022. Is that correct?
Yes.
And a second revised your second revised direct testimony and exhibits were filed on April 1st, 2020. Is that correct?
Yes.
And the only changes to your second revised direct testimony and exhibits were limited to redactions to exhibit HIP 1. Is that correct?
That's correct.
Ms. Hipp, are you the same Dawn M. Hipp who caused to be pre-filed 20 pages of surrebuttal testimony and exhibit and surrebuttal exhibit HIP 1 on March 28th, 2020?
I did.
Do you have any changes, edits, or corrections to any of your pre-filed testimonies or exhibits?
I do not.
If I asked you the same questions today as those posed in your pre-filed testimonies, would your answers be the same?
Yes, they would.
Okay. Mr. Chairman, because the only changes through the versions of Ms. Hipp's direct testimony dealt with redactions, we would propose to simply move in the last filed version of witness Hipp's testimony, which would be the version filed on April 1st, 2022. And so we would ask that at this time, the second revised direct testimony of Dawn M. Hipp filed April 1st, 2022, and the surrebuttal testimony of Dawn M. Hipp filed March 28th, 2022, be entered into the record as if given orally from the stand.
All right. So the second revised testimony, hold on 1 second. Make sure your mics are off because they're very sensitive and they could pick up, private discussion or comments. Second revised. My mic is on, so you can hear me. Second revised testimony, Ms. Hipp, April. What was that first date?
April 1st.
April 1st. And then the second revised testimony on April 22nd, you said?
The second revised of her direct on April 1st, and then her surrebuttal of March 28th.
All right, March 28th. Oh, March 28th. All right, second revised testimony filed on April 1st and surrebuttal testimony filed on March 28th will be entered into the record as if given orally from the stand.
Thank you, sir. Mr. Chairman, ORS would also ask that Ms. Hipp's second revised direct exhibits, HIP 1 through HIP 4, and surrebuttal exhibit HIP 1 be marked as a composite hearing exhibit and entered into the record as the next hearing exhibit.
Thank you, sir. Second revised direct HIP exhibits 1 through 4 and surrebuttal exhibit HIP 1 will be marked as a composite exhibit and entered into the record as hearing exhibit 13.
Thank you, Mr. Chair. Ms. Hipp, are you the same Dawn M. Hipp who caused to be pre-filed 4 pages of settlement testimony in this proceeding on March 31st, 2022?
I am.
Do you have any changes, edits, or corrections to your pre-filed settlement testimony?
I do not.
If I asked you the same questions as those posed in your pre-filed settlement testimony today, would your answers be the same?
Yes, they would.
Ms. Hipp, did you prepare a summary of your settlement testimony?
I did.
Would you please share your summary with the commission?
Certainly. Good morning, Mr. Chairman, Madam Vice Chair, members of the Commission. It's my privilege and pleasure to appear before you today. My settlement testimony supports and explains the settlement agreement reached between the company, Kiawah Island Utility, the town of Kiawah Island, and ORS that was filed with the Commission in this docket on March 28th, 2022. The South Carolina Department of Consumer Affairs, while not a signatory to the settlement agreement, has indicated that it does not oppose the approval of the settlement agreement. The settlement agreement, as you've heard this morning, is the result of earnest, good faith, transparent, and complex negotiations between stakeholders and their diverse interests. The agreement represents a balanced resolution of all of the issues in this rate proceeding and will support the ability of Kiawah to continue to provide reliable and high-quality water and sewer service to its customers on Kiawah Island. The settlement agreement reduces the requested annual revenue requirement increase by approximately $800,997, or almost 60%. Overall, the settlement agreement reduces the revenue increase from 14.10% to 5.77%. As a result, the average residential water consumer using an average of 11,000 gallons of water per month will experience an increase of approximately $5.83 compared to the increase of $8.31 as requested in the company's rate application. The residential sewer customer using 11,000 gallons of water will in fact see no increase in their monthly bill compared to the increase of approximately $3.49 as requested by the application. The settlement agreement works to minimize the overall increase while preserving the company's ability to invest and provide reliable, high-quality service. As discussed earlier, the settlement agreement also contains some non-monetary provisions that are beneficial to the customers. These include an 18-month stay-out provision, which means that absent unforeseen extraordinary conditions, customer rates will not be impacted by a general rate increase for at least 2 years from the date of the Commission's final order in this case. The settlement agreement also includes a commitment by Kiawah to conduct 2 studies before the next general rate proceeding. The first study is a lead lag study to inform the determination of the company's cash working capital, and the second study is a shared service study to evaluate the shared services provided by Kiawah from its parent company, Southwest Water, and affiliate entities. Both studies are recognized, established regulatory tools and represent meaningful incremental innovation in South Carolina regulatory practice that will support the Commission's ongoing efforts to establish just and reasonable rates according to objective and measurable framework. The settlement agreement also includes a commitment by Kiawah to file its next rate case under a rate of return methodology. This certainty around the return methodology will help the parties streamline any issues relating to rate of return in Kiawah's next rate case in order to minimize costs to customers. ORS submits that the settlement agreement is in the public interest, and ORS fully supports the settlement agreement. ORS respectfully requests that the Commission consider approval of the settlement agreement as presented today. This concludes my summary. Thank you.
Thank you, Ms. Hipp. Mr. Chairman, Ms. Hipp is available for questions from the Commission.
All right, thank you, sir. Ms. Hipp, good to see you again. How are you doing today?
Good to see you too.
Got a couple of questions for you. I think I know the answer to this one, but I want to hear it from you, and hopefully you can answer it. What is the difference, in your opinion, of being a signatory or versus not objecting to the settlement?
Well, I'm not a lawyer, so I'm sure there is
That's
a
probably a good
legal
thing.
difference between a signatory and not objecting. From the practical perspective, a signatory is obligated by the settlement agreement. So in the event that a signatory does not live up to its obligations under the settlement agreement, of course, that would allow another signatory, whoever that may be, to ask the Commission to enforce those provisions. In terms of the Department of Consumer Affairs not objecting, I think it's a nod of support to the compromise, but an inability to forgo the positions that they've stated in their testimony. Again, not a lawyer, that's just a layperson's view on signatory versus non-signatory.
Understood. Thank you for that. My last question would be this. Depending on the outcome of the proceeding today, what is a reasonable amount of time to get an order from the commission back in this matter?
I believe that the commission has to render an order in this case by the end of May. May 31st, I think I saw the date as being. So they're, you know, the order will need to come out within the 6-month statutory deadline unless the commission allows an additional 5 days under the statute.
All right. Thank you very much. Fellow commissioners, questions for Ms. Hipp?
Mr. Chairman.
Let's recognize our counsel, Vice Chair Belzer, and then the floor is yours.
Yes.
Attorney Butler.
Yes, thank you, Mr. Chairman. Excuse me, Madam Vice Chair, for interrupting. I'm not sure that counsel for ORS actually moved that testimony into the record on the settlement part. I don't recall hearing it in any event. So I just make that for the administration of the case. Thank you.
Thank you very much, Mr. Butler. Out of an abundance of caution, then, Mr. Chairman, I would ask that Ms. Hipp's pre-filed settlement testimony be entered into the record as if given orally from the stand.
Okay. Ms. Hipp's pre-filed settlement testimony will be entered into the record as if given orally from the stand.
Thank you.
All right. Thank you, Attorney Butler. Vice Chair Belzer.
Thank you, Mr. Chairman. Good morning, Ms. Hipp.
Good morning.
All of the issues that were raised by the parties have been addressed in the settlement agreement, is that correct?
Yes, they have.
And there's really only one kind of sort of open issue, and that would be rate case expenses, is that correct?
That is correct. The amount of the rate case expenses have not been determined as of the date the settlement was signed and filed. The provision does allow that settlement or that rate case expenses accrue up to and through the date of the hearing, and that those will be verified by ORS after the hearing and presented to the commission.
Okay, and when you say presented to the commission, through a late filed hearing exhibit?
Yes,
And ORS will do a letter affirming or attesting that they've looked at those and those have met regulatory standards and are reasonable?
yes, we will.
Okay. Thank you. Appreciate it. That's all,
Thank you.
Mr. Chairman.
Fellow commissioners. All right. There appears there are no more questions for you, Ms. Hipp. You may step down and be excused.
Thank you.
Mr. Chairman, I would just ask to reserve a late filed hearing exhibit related to rate case expenses.
All right. The late filed hearing exhibit will be reserved as hearing exhibit 14.
Thank you. Mr. Chairman, would it be all right? I guess I would ask if Ms. Hipp could be excused absent any objection from the parties or concern from a commissioner.
We have no concern. Parties, any objections?
None.
None? Ms. Hipp is excused.
Thank you, sir.
I believe the next witnesses will be a panel presented by the applicant.
Yes, sir, Mr. Chairman. Kiawah Island would call Craig Sorensen and Becky Dennis to the
All right.
stand.
Thank you, sir.
If you would raise your right hands for me, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I'm having trouble with these things today. Mr. Sorensen, please state your name and business address for the record.
My name is Craig Sorensen, and I'm at 1710 Wood Creek Farms Road, Elgin, South Carolina.
Okay, let's get the preliminaries out of the way. Mr. Sorensen, did you prepare or cause to be prepared 5 pages of direct testimony in this docket?
I did.
Do you have any additions or corrections you wish to make to that testimony?
I do not.
If I asked you the questions in the testimony today, would your answers be the same?
They would.
I move, Mr. Chairman, to admit the direct testimony of Craig Sorensen as if given orally from the stand.
The direct testimony of Mr. Craig Sorensen will be entered into the record, or read into the record as if given orally from the stand.
Mr. Sorensen, did you prepare or cause to be prepared 10 pages of rebuttal testimony in this
I
document?
did.
Do you have any additions or corrections you wish to make to that
I
testimony?
do not.
If I were to ask you the questions in your pre-filed rebuttal testimony today, would your answers be the same?
They would.
Okay. Mr. Chairman, I move to introduce the pre-filed rebuttal testimony of Craig Sorensen as if given orally from the stand.
The pre-filed rebuttal testimony of Mr. Craig Sorensen will be read into the record as if given orally from the stand.
And Mr. Sorensen, did your rebuttal testimony have 2 exhibits, exhibits 1 and 2?
They did.
Any changes you need to make to those exhibits?
No changes.
Mr. Chairman, I move to admit exhibits 1 and 2 to Mr. Sorensen's rebuttal testimony as if given orally from the stand.
Mr. Sorensen's...
Excuse me, into evidence.
Yes, sir, I got you. Mr. Sorensen's rebuttal exhibits 1 and 2 will be marked as a composite exhibit and entered into the record as hearing exhibit number 15.
Thank you. And finally, Mr. Sorensen, did you file 4 pages of settlement testimony in this docket?
I did.
Do you have any changes or corrections you wish to make to that testimony?
No changes.
And I'm going to ask you many of these questions anyway, but if I were to ask you the questions in this testimony today, would your answers be the same?
They would.
I move the introduction of Mr. Sorensen's rebuttal testimony into evidence as if given orally from the stand.
Mr. Sorensen's...
Settlement testimony. Did I say rebuttal? I apologize.
Mr. Sorensen's settlement testimony will be entered into the record as if given orally from the stand.
Okay.
Mr. Chairman, I hate to interrupt, but could I ask Mr. Torini for a clarification?
Yes, ma'am.
I had that Mr. Sorensen had 3 exhibits attached to his rebuttal testimony.
And you are correct, Madam Commissioner. So I would, Mr. Chairman, I would ask the Commission to admit into evidence exhibit number 3 to Mr. Sorensen's testimony, perhaps amending the earlier exhibits.
Absolutely, and Commissioner Caston tapped me on my shoulder about that, so we definitely want to make sure we get those exhibits in. So just to make sure we're on the same page, Mr. Sorensen has 3 rebuttal exhibits.
Yes, Mr. Chairman, I
Okay.
apologize for the oversight.
So let's amend Exhibit 15 to include Mr. Sorensen's 3 rebuttal exhibits that are marked Exhibit 1, 2, and 3, as opposed to Exhibit 1 and 2. Thank you, Commissioner Caston and Commissioner Vice Chair Belzer.
I'm glad we got through that, Mr. Sorensen. Mr. Sorensen, tell the Commission why you're here.
I'm here to testify in support of the settlement agreement that was reached in this docket on behalf of Kiawah Island Utility. I've attached a copy of the settlement agreement as Exhibit 1 to my settlement testimony.
Which, at this point, we move into evidence as an exhibit to Mrs. Sorensen's testimony, Mr. Chairman, because I believe I neglected to do that earlier.
All right, so this is going to be the actual settlement, correct?
Yes, sir.
Yes.
Okay, so, Madam Court Reporter, what exhibit are we on? 16 or 17? 16? All right. So the settlement agreement will be will be marked as hearing exhibit 16 and entered into the record as the same. All right, I think we're good to go.
Mr. Sorensen, the commission's heard about this settlement from the viewpoint of the town. They've heard about it from the viewpoint of ORS. And what I'd like for you to do today is tell the commission about the settlement agreement, some of the highlights in it, from the perspective of the company.
Sure, thank you. And I would echo some of the comments that have been made earlier, that these were complex and lengthy discussions, negotiations that took place over a length of time. So I would like to thank the ORS for leading those discussions, and am pleased to report that we have reached a comprehensive settlement that resolves all the issues among the signatories to the settlement agreement. And since KIU works collaboratively with the town of Kiawah Island, I am pleased to see that it has joined the settlement agreement as well. And while not a party to the settlement agreement, the Department of Consumer Affairs does not object to the terms. Principally, the settling parties agree that KIU should be entitled to an adjustment in rates and charges sufficient to generate additional revenues of $555,000 based upon the test year revenues and after agreed upon adjustments. The agreed upon adjustments are shown in Exhibit 1 to the settlement agreement. And the revenue requirement, as the Vice Chair has asked, will be adjusted to include rate case expenses incurred through the date of the hearing, and that will be verified by ORS. Also, as a part of the settlement, the parties have agreed to set Kiawah's rates in this case and in the next general rate case according to the return on rate-based method. In this docket, the rates will be established based on an 8.69% return on common equity, KIU's actual cost of debt of 4.57%, and a capital structure that is roughly 47% debt and 53% equity. Further, KIU has agreed not to file a general case no sooner than 18 months from the date of issuance of the final order in this case, unless there are unforeseen extraordinary economic or financial conditions. As a result, the next rate increase cannot take effect any earlier than 24 months from the date of the final order in this case.
Could you explain how the settlement agreement is dealing with the pipeline? I know we've heard about this, but let's just, if you could summarize it briefly.
Certainly. KIU requested approximately $2.4 million that it paid to settle a contractor claim for the expense of a second drill that was necessary to run a secondary water supply line to Kiawah Island. In the settlement agreement, KIU has agreed not to include the requested amount in rate base. Rather, KIU will establish a regulatory asset in the amount of $1.8 million to be amortized over 30 years. KIU will not earn on the regulatory asset. Neither will it pursue approximately $1.7 million in legal and expert fees spent in defending the utility prior to the settlement with the contractor.
And do you agree with Ms. Hipp's explanation of the rate impact on the average customer being approximately an increase of
$5.83.
$5.83
Yes.
per month?
Yes, and then the average residential customer will not see any changes to their sewer rates. And that is a reduction versus the application of $8.31 for a residential customer using 11,000 gallons of water, and a sewer bill for that same customer of $3.49.
Mr. Sorensen, do you believe this to be a fair resolution of this dispute?
I do.
Or of this case, I should say.
I do. The terms of the settlement agreement are fair. They are a reasonable resolution to the parties' issues in this proceeding. And it is in the public interest, and I would urge the commission to approve the settlement agreement. As I mentioned, it does represent a fair compromise of vigorously contested and really intertwined issues along the way. Each party gave ground to avoid the uncertainty and expense of a fully litigated hearing.
Thank you, Mrs. Sorensen. Mr. Elliott is going to present Ms. Dennis's testimony, and then we propose to make the panel available to the commission for questions.
Mr. Chairman, if I may.
Yes, you may, sir.
Ms. Dennis, would you please state and spell your name for the record?
Sorry. Okay, sorry.
And these microphones are not very sensitive when you want to be heard, but they're extremely sensitive when you don't want to be heard. So you might want to push it closer to you as you answer the question.
Okay, my name is Becky Dennis. Did you say spell my name?
Please spell your last name.
Certainly, Dennis.
And Ms. Dennis, by whom are you employed?
I'm employed by Kiawah Island Utility.
And what are your, thank you, what are your duties and responsibilities with Kiawah Island Utilities?
I'm the Director of Operations for the utility company.
Now, Ms. Dennis, did you cause to be prepared and pre-filed with this commission 15 pages of direct testimony?
Yes, sir.
Have you had an opportunity to reread your testimony and review it prior to this morning?
Yes.
Do you have any changes or revisions or corrections?
No, sir.
If I asked you those same questions today, would your answers be the same?
Yes, sir.
Thank you. Mr. Chairman, would move the direct pre-filed testimony of this witness into the record as if given orally from the stand.
The pre-filed direct testimony of Ms. Dennis will be read into the record as if given orally from the stand.
And Ms. Dennis, did you have attached to your pre-filed direct testimony 6 exhibits?
Yes, sir.
And have you had a chance to review those exhibits prior to this morning's appearance?
Yes, sir.
Do you have any changes to those exhibits?
No, sir.
Mr. Chairman, would move the 6 exhibits to Ms. Dennis's pre-filed direct into the record as given orally from the stand. Is it given orally from the stand? Will do. Yes, sir.
Yes, sir. And let me just make sure we're on the same page here. I'm tracking that Ms. Dennis filed corrected direct testimony.
Yes,
Is that the testimony you intended to
Yes, sir.
present? Okay,
Yes, sir.
well, I did not say that, and I apologize. So Ms. Dennis's corrected direct testimony will be read into the record as if given orally from the stand. And her exhibits, BD 1 through 6, will be marked as a composite exhibit and entered into the record as hearing exhibit 17.
Thank you very much. Ms. Dennis, did you cause to be prepared and pre-filed with this commission 5 pages of rebuttal testimony?
Yes, sir.
Have you had a chance to review that testimony prior to your appearance here this morning?
Yes, sir.
Do you have any changes or corrections or revisions to your rebuttal testimony?
No, sir.
If I asked you those same questions today, would your answers be the same?
Yes, sir.
Mr. Chairman, we would move Ms. Dennis's rebuttal testimony into the record as if given orally from the stand.
Ms. Dennis's pre-filed rebuttal testimony will be read into the record as if given orally from the stand.
And Ms. Dennis, did you have one exhibit attached to your rebuttal testimony?
Yes, sir.
And have you had a chance to review that exhibit this morning?
Yes.
Do you have any corrections to your one exhibit to your rebuttal testimony?
No, sir.
Mr. Chairman, would move the one exhibit to the rebuttal testimony into the record as the next hearing exhibit.
Yes, sir. Ms. Dennis's rebuttal exhibit 1 will be marked and entered into the record as hearing exhibit 18.
Thank you, sir. Ms. Dennis, last, did you cause to be prepared and pre-filed with this commission 3 pages of settlement testimony?
Yes, sir.
Have you had a chance to review your settlement testimony prior to your appearance here this morning?
Yes, sir.
Do you have any changes or revisions to that testimony?
No, sir.
And again, if I asked you those same questions this morning, would your answers be the same?
Yes, sir.
Mr. Chairman, would move in the 3 pages of settlement testimony of Becky Dennis into the record as if given orally from the stand.
Ms. Dennis's settlement testimony will be entered into the record or read into the record as if given orally from the stand.
Thank you, sir. Ms. Dennis, please tell the commission the purpose of your settlement testimony.
Sure. I'm testifying in support of the settlement agreement between KIU, the Office of Regulatory Staff, and the town of Kiawah Island. The Department of Consumer Affairs does not object to this settlement.
I know, Ms. Dennis, I want you to get as close to that microphone as you can, please. I mean, and it'll move closer to you.
My throat.
Yeah, well, it might seem awkward, but I think it's important for you
Yes,
to do
sir.
so. Now, are the proposed changes to...
Mr. Elliott, if I might, and I apologize, but you can't see it, but I wear hearing aids. And I really do like it when you talk into these things. It does help. So if you could, too
I'll
much
move
Ozzy
closer just
Osbourne.
for you, Mr. Caston.
Yeah,
I think it was early rock and roll and shotguns.
yeah.
I hope I'm close enough now.
Sounds better. It does. Ms. Dennis, are the proposed changes to Kiawah's tariffs and charges acceptable to Kiawah?
Yes, the settlement tariffs and charges have been agreed to by all parties. And it's important to us, the Kiawah Island Utility, that not only the regulator, but also the town of Kiawah is satisfied with the settlement.
Thank you. And what rates result from the party settlement?
The rates, the increase for a residential customer using 11,000 gallons would increase by $5.36 a month.
Yes, sir. And how about residential sewer?
Sewer has no increase in this settlement.
And did you set out the full range of rates as affected by the settlement in your settlement testimony?
Yes, I did.
Thank you. Now, Ms. Dennis, how will the settlement agreement serve the public interest?
Sure. The customers have chosen to reside on Kiawah Island to enjoy life in a secluded oceanfront setting. Providing reliable and high-quality water and sewer service to an island community has significant challenges. Although KIU has made significant concessions, the settlement will permit us to meet the water and sewer needs and demands of our customers and will continue to help us maintain and invest in our water and sewer facilities.
Thank you. And last, Ms. Dennis, do you recommend the settlement to this commission?
Yes, I do. I would especially be pleased if all parties, there would be no parties to object to this settlement.
Excellent. Thank you, Ms. Dennis. Ms. Dennis and Mr. Sorensen, please answer any questions the commissioners may have.
Commissioners, questions for the panel. Commissioner Powers.
Thank you, Mr. Chairman. Good morning to both of you. And in your settlement testimony that was just submitted, on page 2 where you list out the changes, in parentheses at the end of one of your sentences, you said final rates will be calculated after the hearing. Exactly what does that mean, Ms. Dennis?
That is there. That based on, commission approval of the settlement.
It will also include the legal costs through the date of the hearing.
Okay. Have these additional rate expenses, have they been submitted yet or determined
Not yet. I believe that will be accomplished through the late filed exhibit.
Is there a time frame for that? I'm just curious.
I don't think that we've decided on a time frame. I don't think we've decided on a time frame, but it's a very simple calculation these days, and would have it to the ORS this week.
Okay, well, because we've got a deadline on when we submit our order.
No, sir, I understand.
Okay.
If that's timely, I mean, we could probably do it before Friday. I probably need to do it before Thursday, so.
That's fine, thank you.
Thank you.
Mr. Sorensen, again, I'm just curious, your title, both as Kiawah and with your bigger company, I guess it is Southwest, how many, is Southwest a lot of like smaller entities like Kiawah or how?
So Southwest is a nationwide utility with utilities in various states and obviously Kiawah is in South Carolina. We have other assets in South Carolina, other utilities as well. Most recently PWR that we were here discussing 3 or 4 months ago. And I'm president over all of those utilities in South Carolina as well as Alabama and Florida.
Got your hands full.
Yeah.
With these other companies, have you been involved with, we've been told there's going to be a lead lag study. Have you been involved with those before?
We have not had to produce a lead lag study in other filings.
Okay. Do you have any reasonable guess as to what this is going to cost?
I think we looked at that, and I hesitate to offer a vague recollection, but I would, most experts, I think, and studies would cost in the $10,000 range, something like that.
Okay. And there was another study you were going to do, I think it's called shared service study.
Yes, sir.
And that's going to be done by a consultant.
Yes, sir.
Is that consultant going to be somebody who's an independent party from all of the parties involved here?
Yes, it will. It'll be a third party.
Okay. How much that going to cost?
I don't know. I would assume that, and I don't want to telegraph my expectation to future consultants, but
well, we can withdraw that. Okay. We'll just forget that one. Thank you very much.
Yes, sir.
Vice Chair Belzer.
That's right.
Thank you, Mr. Chairman. Good morning, Mr. Sorensen.
Hey, good morning.
Ms. Dennis, it's good to see y'all this morning.
Thank you.
Ms. Dennis, this is to either one of you, but you've got the rates attached or included in your settlement testimony. Am I reading this correctly, that the increases under the settlement agreement, if approved, goes to the consumption part and not to the base facilities charge of the water?
That is correct. Yes.
I mean, we've used or in the testimonies, there's been the example of the impact to the residential customer. But even for other classes of customers, the impact would be on the usage and not the base charge. Is that correct?
That is correct.
Under yours.
On those.
And then there's also, I believe, Kiawah purchases potable water from St. John's. Is that correct?
Yes, that's correct. St. John's Water Company.
And so that charge is done as a pass-through, and that is independent of the increase here.
Yes, ma'am. That's
Okay.
correct.
And there is an exception or not an exception, but there is an allowance under the settlement agreement that does not impact that pass-through rate should St. John's
That is
increase
correct.
their charges to the utility. Is that correct?
Yes, ma'am. That's correct.
And I believe you stated this, but I just want to make sure there is no proposed increase under the settlement agreement to any of the sewer charges. Is that correct?
That is correct.
Okay. Thank you. And I think this may go to Mr. Sorensen. I had some questions on the studies as well. Does the utility, either Kiawah or Southwest, the parent, are there mechanisms in place when studies or consultants are sought to be retained that produce to ensure that you get a good consultant at a fair price? And where I'm going is, this doesn't need to be gold-plated. It doesn't need to be the most expensive for a mediocre product. It just needs to be a good product at a fair price. Do y'all have some sort of parameters to ensure that these aren't going to be outrageous sums?
And I agree with your assessment and view of the studies as well. So yes, when we'll look to pursue a study or speak with experts, we'll speak with multiple experts and have discussions about, what do they envision, this study to be or whatever, and then ask for, price ranges as well to so that nobody's surprised at the end, that you understand the goal of the study or the or the analysis to be performed, and then a ballpark estimate, and that could be based upon an hourly rate or with an estimated number of hours or a lump sum. It depends on the expert.
Okay. Thank you very much.
Yes, ma'am.
Appreciate your appearance here today and your testimonies.
Glad to be here. Thank you.
That's all I have, Mr. Chairman.
Thank you, ma'am. Commissioner Caston.
Good morning.
Good morning.
Mr. Sorensen, I was hearing all the questions about consultants, and having been a former consultant, we used to argue that when it came to building stuff, you typically had plans and supposedly developed really good so that the contractor could develop an estimate from it. He had given stuff, but from a consultant's point of view, we were selling value, product. You want somebody that put good stuff down on paper so that you could get good numbers. So cheapest was not always the best. But since I'm not a consultant anymore, I don't know that I can say that or argue that case. Is it general practice, I guess, of Southwest Utilities and Kiawah, the utilities they're under to require performance bonds on construction projects or major construction projects?
So we will require insurance to the extent of the project. It may require a bond as well, but yes, we have experts in-house that look at those, that look at nothing but insurance and bonding requirements.
Okay, as far as your, I guess, contractor contracts, is there a standard there? Do you have folks look over those to make sure you feel like you're adequately covered contractually?
Yes, we do. Again, we have internal resource that reviews every construction project and insurance requirements based on the project, type of project it is. Is it an excavation, or is it elevated tank, or whatever it is? The level of insurance required may be different.
Is there anything, I guess, that's come out of this particular project or experience that is maybe modified anything or caused Southwest to maybe look at anything differently? Or
so in respect to the pipeline construction project?
Yes, sir.
Yeah. So really, that project had legal eyes on it before Southwest even purchased Kiawah Island Utility, as the contract was negotiated and entered into by Kiawah Island, and then at the time of acquisition, Southwest's legal counsel looked at it as well. I've got personally a background in underground construction and this type of work, and my assessment was that we were covered and protected and had done the right things, and I will maintain that position until the day I die. I will go to my grave believing that the utility was protected and had acted appropriately prior to executing the contract with a contractor. You ask for what would we do differently, who is no longer on our approved bidders list.
I understand.
Yes.
Thank you, sir. And a question for you, Ms. Dennis, if I may. And I maybe should know this, but I don't. Does Kiawah Utility use the treated wastewater for golf course irrigation, or how is that handled?
Yes, all of the treated effluent does go to the golf courses. It's blended with potable and well water as needed. Sometimes the demands are, the golf course demands are much more than the effluent is produced, so.
Well, I was looking through your photos, good photos, and I didn't see a one of the golf courses, not a one. And I was just thinking that might have been a golden opportunity to show some of those wonderful courses, but
They are awesome.
yes, they are. Thank you. I have no more questions, Chairman Williams.
Any more questions for the panel? Ms. Dennis, Mr. Sorensen, I would just like to say thank you for your testimony, and I'd like to say to all the parties, thank you for your work. We've heard a lot of settlements, and it's good to see when the parties come together after working very hard to reach a compromise. So good job. I don't have any questions for you. Oh, I do have one question. I had to run to the restroom, so maybe this was asked. How long will it take to get that late file exhibit? Well, did anyone ask that question?
Yeah, they did.
Okay, all right, Thursday. Thursday, was that the answer? All right, thank you very much.
Thank you.
You all may step down. Anything else? Attorney Butler.
Yes, sir, Mr. Chairman, I just wanted to mention that the parties have agreed on a proposed order date, and that is April 28th, 2022. And if you like, I can attempt to go through the exhibit list that we.
Sure, nothing wrong with that. Make sure we have everything in its proper place.
All right, so just to compare notes, exhibit number 1 was a pre-registration list for the March 21st hearing. Exhibit 2 was the direct exhibit of Mr. Labriola of the town of Kiawah Island. Exhibit 3, Mr. Rothschild's direct appendices A through C, and also exhibits ALR 1 through 6. We had number 4 is direct appendices A and B and exhibits, Mr. Garrett. 5 exhibits, direct exhibits of Mr. Herpel. 6 direct exhibits and verification of Mr. Hunnell. 7 verification Mr. Raymond. 8 exhibits of Mr. Watkins for his direct testimony. Exhibit number 9, we had Mr. Hafiz's direct exhibits, as I understand it. 10, we had direct exhibits of Mr. Loy. 11, rebuttal exhibits of Mr. Nicholson. 12, rebuttal exhibits of Mr. Carlisle. 13, Ms. Hips, second revised direct exhibits, and I believe a surrebuttal as well. 14 is reserved for the filing of rate case expenses later. 15, Mr. Sorensen's 3 rebuttal exhibits. 15, Sorensen's rebuttal. 16, Mr. Sorensen exhibit with a settlement agreement. 17, Ms. Dennis's exhibits 1 through 6, and 18, Ms. Dennis's rebuttal exhibit. So that's the list as I have it, Mr. Chairman.
All right, same list, Madam Court Reporter. All right, we're all on the same page, parties. Any discrepancies? None. All right, so we're good to go with our exhibits. Anything from the parties? Nothing. Commissioners, anything before we adjourn? Nothing. We are adjourned. Thank you very much.